This meeting of the Littleton Licensing Authority will come to order. City Clerk, would you please call the roll?
Authority Member Bradish.
Here.
Authority Member Gunya.
Here.
Authority Member Odell.
Here.
Authority Member Cole.
Here.
Authority Member Mather.
Here.
Authority Member Gallagher.
Here.
We do have a quorum. Next item of business is approval of the agenda for this meeting. Does anyone have any changes to the agenda?
The item 10A, Colleen was telling me there's a later issue and I don't have it.
Yeah, there's a typographical error. The date for Tavern Littleton show cause is January 9th, 2013.
Not December 12th.
No.
Okay, we'll make that modification. I have one change. Item 8, consideration of other applications and requests for liquor licenses. I'd like to add an item 8A, Aspen Grove 0122 LLC, doing business as Fresh Nail Wax and Dry Bar. We have a discussion about that. Are there any other changes?
I'll make a motion the agenda be accepted as modified.
Second.
All in favor?
Aye.
Motion carries. Next item of business is approval of minutes for our last meeting.
Mr. Chairman, I had a question on page 6. The motion regarding Ned Kelly's, it says that you made the motion and that Tony seconded it. I seem to remember it was the other way, but I don't know. Did you make the motion?
I don't believe so. I don't make any motions. I was just seconding that day.
Okay.
He was, oh, never mind.
I believe it's correct.
So that is correct,
Okay.
as stated.
On page 2, section 5, the second paragraph, it made noted that Chairman Braddock and Authority Member Gunya voiced concern about the size of the lien address for the manager of Aspen Grove. I think that was your concern. My concern was that it would not be a reflection of good moral character.
I believe you're correct. I remember it that way also.
And Authority Member Gunya, I already have made that change based on our previous
We each
conversation.
had different concerns about that, and mine is as stated, and Member Gunya had a different.
And that change already has been made. It was made after the packets went out.
Thank you.
And I didn't have a problem with the moral code, but I did agree that we probably should look more into the taxes. And I wanted to note also on every page, it's dated April 11th.
That's probably an error in the footer, but I'll fix that for you.
It probably is.
Do you have something, Kristen?
Yeah, I just wanted to note on the previous comment about who made the motion, we do have a transcript that was prepared by counsel for Ned Kelly's, and looking back on it, it reflects that Authority Member Gallagher made the motion,
Oh, I'm sorry.
and it doesn't indicate who seconds. It says voice, so
We can
I
assume
think
that's
it,
Chairman Bradish. Okay, we'll make those corrections.
if you want to accept that.
I didn't understand the last one. Are you saying that you're changing it to note that Gallagher made the motion?
I was simply noting that the transcript that's provided, that's not provided by the city, it was provided by counsel for Ned Kelly, and it indicates that Authority Member Gallagher made the motion, and then it just says voice seconded. So I think that it likely was Chairman Bradish, but I don't know. You could certainly ask us to go back and listen to it or watch the video.
And I'll do that. I'll go back and
Okay,
make sure it's
because
on the record.
I don't believe I was making any motions that evening.
Okay.
$5.
Step dancing music. Huh?
That's $5, please, sir.
Yeah, you got it.
I'll make a motion that the agenda be excuse me, the minutes be accepted as modified.
I second that.
There is one thing I'd like to bring to attention. I have a transcript of that, and in regards to Ned Kelly's, the chairman said, entertain a motion. Mr. Gallagher, let me find it, and I'll read it. I move, and then, so Authority Member Gallagher did make the motion.
Actually, I think I asked to let me find it, and I couldn't find it quick enough, and Mr. Bradish made the motion. I think we need to
We'll go
look
back
at
and
the
look at the
video.
video.
I just viewed the video. I believe you did make the motion
Okay.
before I came here.
Regardless, there was a reason I seconded it, if anybody wants to know.
So I suggest we have a motion to approve the agenda without making that change, leave it like it is. Do we have a second?
I second that.
Second.
All in favor? Aye.
Aye.
All opposed?
Nay.
Okay.
Motion carries. Next item of business under liquor license cases, item number 8, we have added an item which I mentioned earlier, Aspen Grove. We had called in the last meeting to ask Aspen Grove to come into this meeting and to discuss some tax liens that concern Member Gunia and myself. There's been some development since then that I would like the city clerk to explain to us.
Mr. Bradish, you need to identify it's Aspen Grove Fresh Nail and Wax, not just Aspen Grove Shopping Center.
I stand corrected.
Yeah.
Actually, it's, for the record, it's Aspen Grove 0122 LLC, known as Fresh Nail Wax and Dry Bar at 7301 South Santa Fe Drive, number 342.
That's the way I described it when I put it into the agenda, so excuse my shorthand.
The
City Clerk.
developments on that are, when it was brought to the authority last month, it was based on reports from Littleton Police Department based on the manager at the time of renewal. It was brought to our attention very shortly after the meeting that management for that company changed very soon after the renewal was submitted to us, but we were not notified. So the manager in question with those tax liens is no longer the manager, has not been involved with the company for some time. The company, in fact, not only has a new manager, but a new part owner. And so they are completing paperwork to make that change for the record. When the paperwork is completed, we will do another background check through CBI and our police department. And hopefully nothing derogatory will come up and we'll be able to close this.
Okay, so we'll approve that renewal administratively?
Let's hope.
Okay.
Just to make sure everybody understands, the old manager is not connected in any way. It's
Not at
management,
all.
assistant manager, owner,
Not at all,
assistant
not in the
owner.
business at all.
Do we need to have a motion to clear that out?
I think it probably should have been reflected on the agenda, staying there, and we'll just continue it, because we were waiting to see what was filed. And it may be that they do need to come before you to explain what happened and make those statements that that person is no longer involved. So if it's okay, I'd just like a motion to go ahead and continue it to the next hearing, and then we'll address it in January. I guess it's the January 9th.
January
hearing.
9th.
I'll make a motion to continue consideration of their renewal until next meeting.
I'll second that motion. City Clerk, you want to poll the authority for this one?
Authority Member Bradish?
Yes.
Authority Member Gunia?
Yes.
Authority Member Odell?
Yes.
Authority Member Cole?
Yes.
Authority Member Mather?
Yes.
Authority Member Gallagher?
Yeah.
Motion carried. Next item of business, number 9, findings of probable cause and scheduling of show cause hearing for liquor code violations. Item 9A, the Castle Bar and Grill, 6657 South Broadway. We have three. Do we have a speakers list?
This is a problem cause. They don't get the speaker.
No speakers for this, that's correct. Okay.
This is agenda item 9A, probable cause hearing for T&K Smith Enterprises, Inc., doing business as the Castle Bar and Grill. I would ask that the authority enter in the following three exhibits into the record. Exhibit A, proof of notice to the applicant. Exhibit B, authority communication. And Exhibit C, the Littleton Police Department report number 2012005051.
I'll move that we admit exhibits A through C into the record.
I'll second that.
All in favor?
Aye.
Aye. Opposed?
Okay, the
carried.
issue before the authority is whether there is probable cause to believe that T&K Smith Enterprises, Inc., doing business as the Castle Bar and Grill, violated the Colorado Liquor Code and Littleton City Code and should be scheduled for a public hearing to show cause if any way its license should not be suspended or revoked. This matter comes to the authority as a possible violation of the Colorado Liquor Code and Littleton City Code by the licensee following an incident on September 14, 2012 at approximately 6:55 p.m. Possible violations of the Colorado Liquor Code and Littleton City Code include Littleton City Code Section 3-2-10-F, sale to intoxicated persons. Littleton City Code Section 3-2-11A2, conduct in establishments. Colorado Revised Statute Section 1247-901 and Regulation Colorado Department of Revenue Regulation 47-900. Case report 20120055051 is attached and has been accepted into the record. Section 3C of the Licensing Authority Guidelines states that the authority must consider the probable cause evidence presented by the licensing coordinating officer, and based on the totality of the circumstances, the authority must find that there is a reasonable belief that a violation has occurred based upon reliable information. I'd recommend that the authority find that the probable cause exists sufficient to set the matter for a show cause hearing. The show cause hearing should be set in February 13, 2013 hearing date to allow for a preliminary hearing to be held in January 9, 2013 hearing date in accordance with the licensing authority guidelines. I have included a suggested motion. I would ask that you specifically call out which provisions of the code or all of them listed in the staff report you are finding probable cause with respect to.
It appears that this gentleman was overserved.
I'm not sure that that's the case. The incident occurred at 6:55 p.m. in the evening.
No. 4:55 p.m.
That was the-
16:45.
That was when the bill was paid. When the encounter was made with the officer, according to the officer, it was 6:55. When the gentleman drove his vehicle in front of the police officer on Broadway and then proceeded southbound, then turning upon the Highline Canal Trail. Now, I'm not sure when he paid his bill, but typically it's been my experience you pay the bill at the end. If that's true, if he paid his bill at 4:45, there is approximately a 2-hour period there. I simply don't have enough information. He may have gone out to his vehicle. He may have found a bottle of alcohol. He may have consumed it. He may have ditched the bottle there because the officer did not find any alcohol in the vehicle and then proceeded out. I just don't have enough information when the testimony from Officer McPhee is in talking to, I believe it's the, not sure if it's a manager or owner, Dorby explained that McPhee appeared normal, stating that McPhee is irregular, and so on. So, according to the testimony taken by the officer or the interview by the officer, he appeared normal when he left. What he did in that span, I can't tell.
But, I mean, the standard we're using is probable cause, and it's not normal behavior to go into a bar, buy a drink, leave the bar, and sit in the parking lot for 2 hours continuing to drink. So, I mean, I think based on the standard, I think there is probable cause to believe that a violation occurred. And then we could bring the people in and ask him, did you go sit in the, I mean, in my mind, there is probable cause to ask for more information to find out whether or not a violation occurred.
I tend to lean towards the fact that the bar tab was for $16.50, and it stated they had one shot and one beer. That may or may not make somebody intoxicated, but that doesn't tell me that the person was intoxicated when they left the bar. And whether they sat in the parking lot or drunk, or whether they drove and drank, or whatever they did, there's still a period of time that they could have consumed additional alcohol. There's nothing in here that clearly indicates that an intoxicated person was served.
I'm concerned as to how we would be able to get to the bottom of what took place for those 2 hours. And we would never, I don't think we could prove one way or the other that.
Well, it's
person was
not up to us to
intoxicated
prove.
Wait a minute.
Yeah.
We weren't, I just don't think we can show that we could prove that this person became intoxicated in this establishment because of that gap in time.
Well, this certainly, to me, does not prove that he got intoxicated then, if he had one beer and one shot, and he had a blood test of .202.
Right. I mean, I don't get me wrong. I'm not saying that what we're looking at proves that he was overserved. I'm saying a .2 blood alcohol level is more than one drink.
Right.
And the concerns voiced may be right, but it seems to me it's worth asking him to come in as a witness and say, did you consume alcohol for the 2 hours from the time that your tab was provided? I can see a scenario in which I ask for a check and then sit there and drink a beer for an hour and talk to people. I mean, my point is, I don't know that we have enough information to say that there's nothing here, there's nothing to look at.
I don't think we have enough information either.
I agree with Andrew. I think we need some more information. And just because we find probable cause doesn't mean that we're going to take any action. I think it's a tool for us to investigate exactly what did go on.
I agree.
So, and it is obvious that the man was intoxicated. He pulled out over a curb in front of a police car. It tells me that.
I think the seriousness of a possible consequence of what was done warrants bringing people in and looking into this in more detail. So I'd be open to that if somebody wants to make a motion.
I'll make a motion. I move to find that there is probable cause to believe that T&K Smith Enterprises, Inc., doing business as the Castle Bar and Grill, 6657 South Broadway, Littleton, Colorado, on September 14th, 2012, at approximately 6:55 p.m., did violate the liquor code and Littleton code of sale to intoxicated persons. Based on these findings, I move that a public hearing be set for the 13th day of February 2013 for the purpose of considering the status of the tavern license, wherein the above-mentioned licensee may be present to show cause, if any, why its license should not be suspended or revoked, and further that notice of these findings in the hearing to show cause shall be forwarded and served to 6657 South Broadway in accordance with the provisions of state law. I move that a preliminary hearing, if necessary, be set for the 9th day of January 2013 for the purpose of considering a possible stipulation, if any, between the licensee and the City of Littleton.
Excuse me. May I get clarification on the motion? Are you only including sale to intoxicated persons and not conduct and establishment, the Colorado Revised Statute or the regulation?
I'll add to the motion that that conduct and establishments is also an issue that it's also a violation that could have occurred.
Okay, and the state statute and regulation?
Yeah, and Colorado Revised Statutes 1247-901.
And regulation 47-900?
And state regulation 47-900.
You, a second?
You're welcome.
I'll second that.
We have a motion and a second. Is there any discussion on the motion?
Well, I understand that in accordance with the regulation, probable cause does not require sufficient evidence to show that a violation occurred.
That's correct.
That is the purpose of the show cause hearing.
Well, the purpose of the show cause hearing is to ask the licensee to respond to our contention that there's probable cause that there was an offense, and they have the opportunity to show cause why there shouldn't be a suspension or a revocation.
They also have the opportunity for a preliminary hearing in a month also,
Yes.
at which point they can raise some arguments that might change our mind to go forward with the show cause hearing. Was this motion seconded?
Yes.
Okay.
Poll the authority, please.
Authority Member Bradish?
Yes.
Authority Member Gunya?
No.
Authority Member Cole?
Yes.
Authority Member Odell?
No.
Authority Member Mather?
Yes.
Motion is carried. Next item of business, probable cause hearing for the Toad Tavern, 5302 South Federal Circle, number A.
This is agenda item number 9B, probable cause hearing for Toad Tavern, Inc. I would ask that the authority accept into the record Exhibit A, proof of notice to the applicant, Exhibit B, the authority communication, and Exhibit C, Littleton Police Department report number 2012006382.
I move that we accept Exhibits A, B, and C.
Second.
All in favor?
Aye.
All opposed?
The issue before the authority is whether there is probable cause to believe that Toad Tavern, Inc. violated the Colorado Liquor Code and Littleton City Code and should be scheduled for a public hearing to show cause, if any, why its license should not be suspended or revoked. This matter comes to the authority as a possible violation of the Colorado Liquor Code and Littleton City Code by the licensee following an incident on November 23, 2012 at approximately 6:34 p.m. Possible violations of the Colorado Liquor Code and Littleton City Code include Littleton City Code 3-2-10F, sale to intoxicated persons, Littleton City Code 3-2-11A2, conduct in establishments, Colorado Revised Statute 1247-9011A, and Regulation 47-900. Case Report 201200638 is attached. Section 3C of the Licensing Authority Guidelines states that the authority must consider the probable cause evidence presented by the licensing coordinator officer, and based on the totality of the circumstances, the authority must find there is a reasonable belief a violation has occurred based upon reliable information. Probable cause does not require sufficient evidence to show that a violation occurred. That is the purpose of the show cause hearing. Staff recommends that the authority find that probable cause exists sufficient to set the matter for a show cause hearing. The show cause hearing should be set in February 13, 2013, hearing date to allow for a preliminary hearing to be held in January in accordance with the licensing authority guidelines. I would ask that in your motion, if you do find probable cause, that you list the specific areas or the specific code violations that you are finding probable cause with respect to.
I find this one to be a lot different than the last one in the fact that we have people who says, yes, I was drunk when I went to the bar. Yes, I was drunk when I was served. We do have witnesses that says that. Having said that also, I must admit I went to the CU football game and felt like getting drunk afterward also, but I did not.
Well, and also a citation was issued
Yeah.
to the bartender. So I think we need to look into this one more closely.
In my opinion, there clearly is probable cause here, just because of the witnesses that stated the offense was committed and the fact that there was a citation. I would tend to go along with that.
There's also an issue of conduct in the bar, too, broken glass, and were the police called, or were they just in the area?
Mr. Chairman, I'd make a motion, if I may. I move to find as plausible cause to believe that Toad Tavern, 5302 South Federal Circle, Littleton, Colorado, on November 23rd, 2012, at approximately 6:34 p.m., did violate the Colorado Liquor Code and Littleton City Codes, specifically the Code 3-2-10F, sell to intoxicated person, 3-2-11A2, conduct and establishment, 12-47-902, and also Regulation 4790 that requires them to conduct the premises in a decent, orderly, and respectable manner.
If I can just clarify, the statute reference is 1247-901.
Yeah.
Thank you.
Fair
You
enough.
said 902, it's
And
901.
based on said finding, I move the public hearing be set for the 13th of February, 2013, for purpose of considering the status of said license, wherein the above-mentioned license may be presented to show cause, if any, why its license should not be suspended or revoked, and further that notice of these findings in the hearing to show cause shall be forwarded and served to 5302 South Federal Boulevard in accordance with the provision of state law. I move that a preliminary hearing, if necessary, be set for 9th day of January 2013 for the purpose of considering a possible stipulation, if any, between the licensee and the city of Littleton.
Mr. Chairman, I'll second that.
Would you poll the authority, please?
Authority Member Bradish?
Yes.
Authority Member Gunya?
Yes.
Authority Member Cole?
Yes.
Authority Member Odell?
Yes.
Authority Member Mather?
Yes.
Motion is carried. Next item of business is number 10A, which is a preliminary hearing for Littleton Tavern, 2589 West Main Street.
And that date has been corrected for, that's actually moving forward to January.
January 9th.
Right.
James Byford, appearing on behalf of the Tavern, Littleton. That's our understanding that this would go forward to the January meeting. And I guess we'll see in January. We're hopeful we'll still can resolve something. But our understanding was tonight we would have to accept a certain stipulation if we were to go forward tonight. And we would prefer to still talk with the city attorney and see if we can resolve something.
Okay, you realize that we have a show cause hearing next month.
Yes,
Yes, okay,
January 9th.
okay. And which raises a question for the city attorney is, do you plan on having some stipulation at that point in time, or are you ready to go with witnesses and everybody else? Because if you don't come up with something acceptable, we will have that show cause hearing.
We understand that.
Okay.
If we don't have something worked out ahead of time, that's the consequence. We'll have the hearing.
And if we can't come to an agreement, the show cause hearing is going to be next month.
That's my understanding.
Okay.
Yeah, and my understanding tonight was only if we could accept a certain term of a stipulation, and we were unable to come to agree to that, I guess, predetermined situation. So we're going to try to discuss it further.
Okay.
Thank you.
Thank you. Okay.
Do we need a motion in that we already have a motion calling for the show cause hearing next month in
Correct.
the absence of a stipulation?
Correct, it's set. It's already set for January.
All right, so that's already scheduled and it's already in the record.
Yes.
Next item of business, item 10B, Ned Kelly's Irish Pub, 5686 South Sycamore Street.
Yes, this is agenda item number 10B, a preliminary hearing for Ned Kelly, Inc., doing business as Ned Kelly's Irish Pub. The issue before the authority is whether the licensing authority should grant the motion to dismiss, which was filed by Ned Kelly, Inc., doing business as Ned Kelly's Irish Bar. On December 5th, 2012, Ned Kelly, Inc. filed a motion to dismiss with the licensing authority. A copy of the motion is attached to the communication, which you should have received this evening. The city filed a response to the motion to dismiss on December 11th, 2012. A copy of that response is also attached. Under the licensing authority guidelines, the parties at a preliminary hearing may make legal motions regarding any matters that would be heard at the show cause hearing, so it's appropriate for you to address this motion at this time. The licensing authority is being asked to rule on the motion to dismiss. Both the city and the licensee have been advised they will have the right to address the authority on the merits of the motion. Additionally, in the response filed by the city is asking the licensing authority to provide clarification as to which of the violations were included in its probable cause determination at the hearing on November 14, 2012.
Before you get started, what were the exhibits?
Sorry. The exhibits are Exhibit 1, the motion to dismiss, dated December 5th, 2012, filed by Ned Kelly, Inc., doing business as Ned Kelly's Irish Pub. The response to motion to dismiss, dated December 11th, 2012, filed by the city. And the letter from Deputy City Clerk Norton, dated December 6th, 2012, setting this matter to be heard this evening.
So was that 1 through 3 or A through C? Okay, I'll move we admit exhibits A through C.
I'll second that.
All in favor?
Aye.
Aye.
No opposed? Counselor?
Good evening, Mr. Chairman, members of the authority. I'm John Stonebreaker, appearing on behalf of Ned Kelly's. First, I'd like to apologize. I'm just getting through some laryngitis, so if my voice cracks, it doesn't have anything to do with the case. It's my medical condition, and I apologize because I know my voice is rough. Very briefly, if I may, my client and I both appeared for the first hearing, the finding of, or when the board considers whether or not there is probable cause to proceed. And we both sat and listened to the entire hearing. And when I left the hearing, I was under the firm impression that the board had found probable cause on failure to report a violation, but that the board had not found probable cause to support any other charge of any other kind or character. Thus, when I received the show cause order from the city charging essentially 3 violations, I was taken aback, and that simply was not what I had heard at the hearing. It turns out that the city has transcripts of these, or rather a video of the proceeding available online. We hired a outside court reporting service to prepare for the board a transcript of that, and what I've attached to the motion is that transcript that's prepared by the outside court reporting agency. And I'm asking the board to look at page 4 of that transcript that's attached to the hearing, and this is exactly the conversation that the board was discussing earlier. And in my view, there's a very clear statement by Mr. Gallagher that says this is about failure to report a bar incident. I believe the chairman states an agreement with that proposition. Then there is a motion, and I think this might actually be the problem. There's a general reference to the liquor code and the Littleton City Code, as opposed to a specific charge, which you will notice the city has been very careful to cover this evening. And I just have to think that that's predicated on this misunderstanding, or everyone's impressions of what was going on was not the same. And what I'm asking is that the portions of the motion or of the show cause that relate to anything other than a failure to report an incident basically be declared or dismissed, and that the city affirm, that the licensing authority affirm that those are not part of the case. And I note that the city in its response is also asking that for clarification as to which, if not all, of the violations are included in the probable cause determination. So I think we're essentially asking for the same relief for this to be cleared up.
Can I just ask for a point of clarification? The motion to dismiss that I'm looking at, paragraph 1D, since the Littleton Licensing Authority did not intend to find probable cause relating to both sale of an intoxicated person or conduct in the establishment, the licensee respectfully requests that the order to show cause dated November 15th be dismissed in its entirety. So are you asking?
Just standing here, I got to tell you, I think the city did find probable cause.
Okay.
Relative to the failure to report. So this is me writing too fast to get my motion out the door.
Okay.
But I think the city, it is fair to say that my client has been properly charged with the failure to report an incident.
Counselor, if I may, is failure to report a state or a city requirement?
It's my understanding is it's a city charge, and my understanding is there is no state-imposed obligation to report a disturbance.
Then when the motion was made that there was a violation of the Colorado Liquor Code and the city code, how do you interpret the fact that the motion said that there were violations of the Colorado Liquor Code?
Well, and the way that I interpret it is to take the discussion as a whole rather than one sentence out of that discussion. And I'm looking at the remarks of Mr. Gallagher on page 4 and the remarks of the chairman on page 4, each of them reaching the conclusion that the only thing that is a problem is this failing to report a bar incident. Sir, I will agree there is a disconnect between these statements and the order to show cause that actually issued from the city, and that's why I'm standing here in front of you this evening.
But when I look at the motion, which I have to look at, and it says you did violate state and city, then I understand the city you're agreeing with is a proper thing to say, to the fact that it wasn't reported. But when I look at the fact that it said you did violate Colorado Liquor Code, I have to make an assumption that there were other violations that was Colorado Liquor Code above and beyond the failure to report.
Well, and sir, I'm not saying that's an unjustifiable position, except when you look at the specific rather than the assumed comments of Mr. Gallagher and the chairman, who specifically say this case is about one thing, which is the failure to report. And there is simply a disconnect or a non sequitur between the motion, those comments, and the order to show cause that issued from the city.
Comments are comments, and I have to look at the motion, and the motion is what was approved.
Well, I'm not sure I agree. I believe that the motion was predicated on those comments. I don't think there was a stoppage in time there.
Could I,
Sure.
if you mind, could I ask our counsel what, as far as options, we could accept his motion or deny his motion, right? Are there additional options as to what we could do?
There are three options
Okay.
for you. You can grant the motion to dismiss, or you can deny the motion to dismiss and just move forward on, I think everyone is in agreement that there is a failure to report charge. Or you can deny the motion to dismiss and clarify that the motion was intended to capture more than just the failure to report charge. There were 4 different violations issued, and clarify, I think the parties are just asking you to clarify which charges that motion was meant
And
to
so
capture.
would that be a two-step process? We would deny their motion, and then if we were to choose to do that, deny the motion for dismissal, and then make a separate motion to clarify, or would it be?
I drafted a suggested motion. I drafted either a motion to grant the motion to dismiss or a motion to deny, and if so, I think you can just include the clarification as part of that motion.
I was not here. I was absent at the last hearing, but before coming to this evening's session, I viewed the last session of the authority, its entirety, before I came here. And the transcript doesn't say that it was one thing. Mr. Gallagher, I think really it's the only thing that we really have to deal with. And the chairman said, I think that's the only thing we're looking for in a situation like this. Anyone else? At that point, the chairman looks to the other authority members, and there is a very sufficient pause to give the other authority members an opportunity to think and come to conclusion, and nothing else is said. Now, this evening I observed that, and I think rightly, that when we went forward with in the probable cause hearings, we were very specific in which violations of either the state or the city ordinance was involved or the regulation. We were very specific. And in lack of that specificity, to say that that it is the Littleton City Code in the motion after very specifically a member of the authority and the chair said that that is the only thing we're looking for. There was no response for any member of the authority. I believe counsel for the licensee and the licensee need to depend upon the good faith of the authority in assuming that that is what they were going to have to address.
And may I say,
The disconnect between the two.
yeah, that my intention was to have probable cause for not calling the police for failure to report was my intention.
And I agreed with that.
And you agreed, right? So where do we go from here?
To me, there is,
The
Because
city still
if there are other violations that they're being charged with, I believe my intention was not to charge them with that
But
in the motion.
the city should have an opportunity to present their side of the motion before any decision is reached. So if you
Okay,
could allow
well,
her to
that's why I
present.
asked where do we go from here?
Well, first of all, the city had given proper notice of all the violations to the licensee. I think that was pretty clear in all the exhibits that were presented to the authority on that particular night. The city would argue that, you know, it's happened tonight, that oftentimes there are issues in the violations that the authority may spend a little bit more time on when they're discussing probable cause. There may be areas of the case that are more concerning than others. Just because the transcript shows that there were discussion on the failure to report, I would argue that that doesn't necessarily mean that there wasn't any other support to the particular violations that occurred. The city would submit that based upon the report that was presented to the authority, Exhibit C, there is definitely adequate support for sale to intoxicated persons, as well as the conduct in establishment, which would go beyond the failure to report. The city tonight is asking for a discussion for a cure. Clearly, as has been indicated, I think there's an agreement that there is definitely a failure to report issue that we need to investigate. I think at this point there needs to be additional discussion as to the other two portions of the violations that were presented, and we're essentially asking for the authority to potentially cure what was evident in the transcript.
So my question from before, and I guess maybe I'll try to restate it, is did we have a one-time chance? Or and so that's what I mean, is because I fully appreciate the question of due process, that if it appeared as though they were being asked to answer to a certain charge and then there were additional charges, I can understand that their concern. So my question is, can we now clarify, give them proper notice, and that is acceptable?
Yes, because remember at the probable cause hearing, they don't have an opportunity to address you. It is simply based on the evidence. So if, it is there, it's in the record, you accepted those exhibits into the record, we're just looking for clarification, which is why we're being so clear tonight about exactly which provisions that are in the report, because certainly when I drafted the motion, the suggested motion, referring to the city code and the liquor code, I meant the violations that were referred to on the previous page listed there. So yes, we're asking for you to cure that. I think it's appropriate for you to do that at this time. And I think all parties would appreciate that clarification.
In which case, I do have to agree that the plain language goes beyond a failure. I mean, the plain language of the motion goes beyond failure to report. And so if we have I guess my question to the authority members would be, do you think there's probable cause for something beyond failure to report? And if so, could we clarify that now?
I think that when I looked at it, I felt that there are people who had blood alcohol levels high. There were other indications of problems in the establishment. And I believed we were given the establishment the opportunity to come forward and show what the problem was and whether or not we should or should not revoke or suspend their license. And it was not just a matter of reporting, it was all the incidences that took place within the establishment.
And I agree with the amount of alcohol that was served in a short period of time. I'd like to look more at that. And also the conduct.
I mean, there was question as to who called the police. We don't know if we didn't know from the information we had available, we didn't know who called the police. We didn't know if it was a failure to report from the information we had. There was just an awful lot of questions about what took place. I mean, there was a fight, there was somebody cut, there were different individuals that had slurred speech, were intoxicated.
Earl, one of this gentleman, Timothy, called 911 from Ranky's parking lot. That's how the police were notified. So Ned Kelly's didn't call the police.
Right, but I mean, like I said, I think everyone seems to agree that there is a failure, that there is probable cause of failure to report. So, I mean, I would agree. But I would agree with Earl that there seem to be other issues of possible violations. And I guess my point is that if we can make that clarification now, it would offer them the opportunity to still prepare a defense of that. And so that seems proper to me.
Are you suggesting that we have a second probable cause hearing and officially find that there's probable cause for these Colorado revised statutes that are supposedly, allegedly violated, and then give them another month to prepare a preliminary hearing and then put a show cause hearing off till February?
No, I mean, as I understand it, if that were to be if we could deny the motion to dismiss and clarify our intent that there is probable cause for, as the plain language of the motion said, violations of the city and state liquor code, which would still provide them the opportunity to defend themselves a month from now.
And Mr. Chairman, I make a suggestion that we have a motion on whether or not to dismiss the motion, and then we have a further discussion.
Then we proceed from there, which would probably
Do we
result in
proceed,
another-
this would be another show cause hearing, because that is what we are doing. We are probable cause hearing, because at the time that the chairman asked for any other discussion, anyone else, adequate time was given to the authority members to respond to their concerns about the blood alcohol, the fighting, all the rest. There was no response, and then it went forward on what was, I think, a clear assumption by the licensee that it was only on that. Now, quite frankly, in my looking at the police reports, I had concerns that the others were not addressed. But the point, in fact, is they were not. So,
but the motion, the plain language of the motion, was violation of city and state, liquor violations. And as Earl's pointed out,
Which
failure
ones?
to report.
That's what we will
Failure
discuss.
to report is not included in state liquor laws. So therefore, in my mind, there's something beyond failure to report. I mean, the plain language of the motion states that.
it states city code as well.
Right. So we have 1, city code, and 2, state. And so how can we, and if we understand that everyone acknowledges that failure to report is not under the state, is not a state violation, then how are we to not believe that there were other issues beyond failure to report when that's the motion? We found probable cause. We voted yes to find probable cause that violations of city and state code took place.
I don't think just because there wasn't any further discussion, you can assume that we weren't going to take those other instances into consideration at a show cause hearing.
Do you think that it is reasonable to give the licensee and their attorney, since they were under a different impression, time to get with the city attorney and have come back for a preliminary hearing and prepare another, in order for them to prepare a stipulation?
When were they notified of?
They received their notice of show cause the day after the hearing, November 15th, and they were provided notice that they were to show cause with respect to all the violations listed in the report, the conduct in establishment, 3210F, 3211A2, Colorado Revised Statute 1247-901, and Regulation 47-900.
So they were notified of the show cause hearing in January, and they were notified they had an opportunity for a preliminary hearing this evening, and they chose to file a motion to dismiss
Right, because at the
instead
preliminary
of
hearing.
going forward with a preliminary hearing.
Well, the preliminary hearing, that is the appropriate time to deal with motions such as this.
Okay.
So it's appropriate the way it was handled.
Do you have further comments, sir?
Well, the point I'm trying to make is this. We did not believe the notice to be validly issued because of what transpired at the authority hearing. So that's why the motion to dismiss was filed, because we didn't believe that that was what the authority had in mind when it voted. If the authority desires to change its ruling and issue a show cause, I am going to ask for the additional 30 days, because the 30 days that I just used up filing the motion to dismiss, I would like to investigate the case and see if there was a stipulation that might be acceptable to the city. So I would be asking for the final hearing date to be pushed the 30 days to give me time to do my work in accordance with the rules of the city.
We don't have any objection to that, but we would need a motion indicating that the preliminary hearing then would be in January and the show cause would then be moved to February.
Okay. Personally, I don't have a problem with it either. I think
don't
that
either.
what we might need to do is vacate our probable cause hearing from last month and make a new probable cause hearing and deny the petition to dismiss and go forward with a new preliminary hearing next month and a show cause hearing in February. I don't know how that motion is going to read.
Let me take a stab at it.
Okay.
I move to deny that the motion to dismiss filed by Ned Kelly Incorporated, known as Ned Kelly Irish Pub, and a public hearing be scheduled for February 13th, 2013, wherein Ned Kelly, known as Ned Kelly Irish Pub, will be present to show cause, if any, why its license should not be suspended or revoked. And specific violations to be addressed is 3-2-10F, sales to intoxicated persons, 3-2-11A2, conduct in establishment, 12-12-901, number 1, and Regulation 4790, which is conduct in establishments.
Let me clarify that the Colorado Revised Statute reference is 1247-901. And I would also ask that you add to the motion that we schedule the preliminary hearing for January 9th, 2013. Thank you.
I will second that.
Any further discussion?
Sounds like a
Poll the
winner.
authority, please.
Authority Member Bradish?
Yes.
Authority Member Gunya?
Yes.
Authority Member Cole?
Yes.
Authority Member Odell?
Yes.
Authority Member Mather?
Yes.
Motion is carried. So it'll be the January, there'll be a
We'll have a preliminary
possibility
hearing.
of a
then
January
for
preliminary
stipulation in
hearing
January.
and a February show cause hearing.
Thank you, members of the authority. I appreciate your fair consideration of the licensee's request. Thank you.
Appreciate
Thank
you,
you for pointing that out to us, Counselor. Okay.
Now, after all this paper shuffling, I have to find the agenda.
Yeah, give you
Killing
some
a lot
room.
of trees here.
All right, next item of business is item number 11A, which is a show cause hearing for liquor violations. My apologies if I mispronounced this name. Vasilios Frangiskakis, doing business as Old Mill Brewery, 5798 South Rapp Street.
Long time no see.
Yes, sir.
I'll introduce the matter.
City Attorney.
This is agenda item number 11A, a show cause hearing. I'm sorry about this pronunciation. Vasilios Frangiskakis, doing business as Old Mill Brewery. The issue before the authority is whether Vasilios Frangiskakis, doing business as Old Mill Brewery, violated the Colorado Liquor Code and Littleton City Code, and whether its license should be suspended or revoked. We have the following exhibits that I would ask be accepted into the record. Exhibit A, proof of notice to the licensee. Exhibit B, proof of posting of the premises. Exhibit C, the authority communication. Exhibit D, Littleton Police Department report number 2012-003429. Exhibit E, proof of subpoena, notification to witnesses. And 2 additional exhibits, Exhibit F, bar tabs, and Exhibit G, witness statements.
I'll move that we enter the exhibits A through G.
I'll second that.
I didn't hear, did you mention the speakers list? Okay. I second that motion. All in favor?
Aye.
Aye.
Thoroughly seconded.
Barely second.
We already had a second. Okay. Motion carries.
All right, and I'm going to ask for another motion because Colleen just pointed out to me that it was not listed as an exhibit. So Exhibit H, which is the
Public hearing roster.
public hearing roster.
This is Exhibit H.
I'll move we admit Exhibit H.
Second.
All in favor?
Aye.
Would the, Mr. Stonebreaker, would you like to proceed?
Yes, sir. For the record, my name's John Stonebreaker. I am appearing on behalf of the licensee, Mr. Fran Giskakis, and I'd like to explain to the board, I was not hired until after the conclusion of the second hearing that has been held in this particular matter. However, I have been working diligently with my client since that time, and I have reached a stipulation with the city that I would like to present to the board. I believe the city is going to be in agreement, or the city has agreed to stipulate to the following. There are essentially 2 charges pending in this particular case. One is sale to a visibly intoxicated person. The second is conduct of establishment. The stipulation is that my client would accept a finding of a violation of sale to a visibly intoxicated person, and in exchange, the charge of conduct of establishment would be dismissed. My client would step forward, accept responsibility for the sale to the visibly intoxicated person, would be allowed to present a mitigation case before the board reached conclusion relative to penalty in this particular case. So that would be a finding that we would consent to, if you will, and then the second charge, conduct of establishment, would be wholly dismissed, and we would proceed to the penalty phase of the hearing. And I believe that that is our agreement, and I believe the city will say so.
And the city would concur with that.
And I apologize that we didn't have it done 30 days ago. I simply wasn't in the case until 29 days ago.
Understood.
So just to be clear, the process that you're describing is that you agree to stipulate to the facts of the over-serving, and then from there you'd like to present mitigating factors that would weigh on our...
Precisely.
Okay.
You're exactly correct. The board would find one violation, it would dismiss the second allegation, and we would proceed to mitigation, anything that the city might have to say about penalty.
Do we need a motion and vote on that?
Yeah, I think we should have a motion on that then to proceed.
I think we need a motion to drop the one violation and find the over-serving violation. And at that point in time, have discussion about it, and after we hear the mitigation, then decide on what type of penalty would be involved.
Well, we would have to have a motion to To accept the
Yeah,
stipulation.
could the motion be to
Right.
accept? So I'll make a motion, and then I'd be happy to discuss in case. But I'll make a motion that we accept the stipulation that the licensee and the city have agreed to, that a violation of Littleton City Code 3210F, sale to intoxicated persons, did occur, and that we will vacate any charge of Littleton City Code 3211A2, conduct of establishments.
There's also a state and a CRS involved with that too, Andrew. The serving intoxicated is a Colorado revised statutes.
Do we need to include?
I would ask the city to clarify which codes we are proposally violating and which codes we are proposally discussing.
While we're looking at it, just 1 second. I think the state statute, CRS 1247-901, would be included, and then not the regulation. So that we're dealing with violations of Littleton City Code 3-2-10F and Colorado Revised Statute 1247-901. Counsel for licensee agree.
Yes, I believe the same set of facts makes out a violation under both the city code and the state code. So my point is there's one violation.
Right. Okay.
Which is sale to a visibly intoxicated person.
Okay, then I will withdraw my original motion, and to clarify, I will make a motion that we accept the stipulation that a violation did occur of Littleton City Code 3210F and Colorado Revised Statutes 1247-901, sale to an intoxicated person, and that we vacate any other charges.
Second.
Any further discussion?
No, it sounds fair to me.
Poll the authority.
Authority Member Bradish?
Yes.
Authority Member Gunya?
Yes.
Authority Member Cole?
Yes.
Authority Member Odell?
Yes.
Authority Member Mather?
Yes.
Motion is carried. We'll proceed to the penalty portion.
Thank you, Mr. Chairman. Sir, I have one witness to call this evening, the owner of the establishment, Mr. Bill Frangiskakis. And, sir, would you step forward?
Good evening.
Know if you swear witnesses in
We-
mitigation phase.
We don't swear in, we would like your name and
My name is Vasilios Frangiskakis. I own the Old Mill Brewery.
Mr. Frangiskakis, I think your laryngitis might be worse than mine.
I totally agree with that.
I don't know, well, I'm moving.
Struggle through and get this done.
Correct.
All right. Sir, you're the 100% owner of this establishment?
Correct.
And how long have you been in business in the city of Littleton?
Approximately 5 years. Will be 5 years in April.
Okay.
Excuse me, how many years did you say?
5 years?
5 years.
5 years.
I never know if it's my hearing or your laryngitis, so we're going to make
It might be my Greek too.
you might make a great pair this evening.
Yes.
And in your 5 years in the city of Littleton, you had one violation on your liquor license in 2009,
Correct.
and no penalty per se was issued in connection with that violation. You were issued suspension or probation, I want to say, for 1 year.
Correct.
And you had no problems in the subsequent year. So your penalty was the successful completion of that probation?
Correct.
All right, thank you. And, sir, were you present at the restaurant the evening that this violation took place?
No, I was not.
And why is that?
I have taken off for a year and a half because I had multiple surgeries on my knees. And I was in a wheelchair for about 3.5 months. And I didn't start working too lately.
Okay, so the events that we're talking about this evening took place in your absence?
Correct.
Okay, thank you. And, sir, briefly describe the restaurant for the benefit of the licensing authority, if you would. And I don't know that they need to be marked as an exhibit, but I do have some sample menus. If it's acceptable, I'd like to pass forward so the board could look those over briefly. And, sir, describe the restaurant for the benefit of the authority.
We're a family-oriented restaurant. Majority of our business is dinner and lunch. We do serve liquor and we do make beer. But 80% of our sales are in food. We do not stay open late. We close in the restaurant time, 10 o'clock at night, weekends at 11. And we do not promote a bar type of atmosphere. We are a family-oriented restaurant.
And you accept full responsibility for the violation as I previously stated to the board?
Yes.
Okay, thank you. Describe your policy on how your employees are trained relative to the sale of alcoholic beverages under the state liquor code and the Littleton liquor code.
Well, my employees have tips. They're trained. My manager at the night is tip trained employee, and we do not have an over-serving problem. We had an instance of one evening that somebody got so overserved by default, I don't know what else to say.
And it's fair to say the restaurant was very busy the night that this occurred?
Correct.
All right. And the violation actually took place between a bartender that was in training and a senior staff member of yours that was conducting that training?
Correct. My senior member has been with me for approximately 3 years. The other bartender was her first night training. They got overwhelmed. The person got drinks from both bartenders. Once they saw that the person was intoxicated, they stopped serving them, called the authorities, called the ambulance, and whatever else we did.
Thank you. And generally, at what age are we asking for identification in this restaurant?
We will ask identification for just about everybody, except our regular customers that they come in on a regular basis and we know who they are. But we always ask for ID.
Okay. And I'm going to ask that I have one document marked as an exhibit, and I'll hand one copy of that to the city.
Exhibit I.
Sir, I'd like to hand you a document that's been marked as Exhibit I for the record. And would you describe that document, please?
This is a document with...
Excuse me a minute. Do we have to accept Exhibit I into the records before we proceed?
Yes.
I'll move we accept Exhibit I.
Second.
All in favor?
Aye.
Thank you.
Do we have a copy of Exhibit I?
Yes, if I may step forward, I have copies for each authority member.
Be great.
So go ahead and describe that document for the record, please.
It is a small portion of a list of businesses and entities that we provide year-round. We give them food or we give them whatever they need without charging them, I don't know, charity-wise. And it's a very small list of what we do for the community of Littleton.
So the 17 separate events that are listed on this are a portion of your community service work?
Correct.
And your restaurant performs and helps out with these events or gives money or whatever's food, whatever's necessary on a going forward basis relative to these events?
Correct.
Okay, thank you. And sir, you're the registered manager at this location?
Yes, sir.
And just finally, would you describe how long have you been in the food and beverage business for your career?
I've been in the business for 35 plus years. I've owned numerous restaurants and establishments.
All right, and those have been in other states as well as the state of Colorado?
Correct.
All right. And in all of your 35 years of being in business, my understanding is that the violation that you are accepting responsibility for this evening is the second violation.
Correct.
And the first was in the city of Littleton, and that would have been during calendar year 2009.
Correct.
Thank you. I don't have any further questions, Mr. Frangis-Kakis. Sir, maybe you could just take a seat.
Thank you.
Thank you.
Thank you.
Thank you. Can I ask the city to clarify, in 2001, so it sounds to me like there was something held in abeyance. Do we know what that was?
2010.
Was it 2010? I thought I
In
heard 2009.
2009.
When did a violation occur?
There was a violation December of 2009. It came before the authority February of 2010 for a stipulation. It was a conduct and an establishment charge. The stipulation that was reached was 1 day, and 1 day held in abeyance for the course of the year.
Well, just one thing I'd like to ask, is this bartender still tending bar? Has she been trained better?
Yes, sir. We accept responsibility for this violation because the establishment got so busy. And, she was in training, and, it was just unfortunate that we got so busy that night. There were some big parties in, and the person that was training this particular bartender got called away to deal with the big parties. And, frankly, we just got caught with a bubble of business that was not being anticipated that evening. That is the reason that the violation occurred. The bartender is still with us. Mr. Frangis-Kakis could not in good conscience terminate the bartender because we felt that she had been placed in an unfortunate position. And she did her best with the situation, but, the whole point was that she was in training, and we just got caught at a bad time. And that's frankly why the violation occurred.
And from this point forward, your training includes the phrase, "Don't sell 5 double shots within an hour"?
Yes, you don't want to hear what I had to say to the bartender.
Okay.
So,
Go ahead. I was just going to say, so she's now got approximately 6 months more experience and training.
It's an awful way to learn, and we just didn't feel it was fair to terminate her based on the facts of the occurrence. But I completely agree. She got the message.
And he said that they go through tips training, is that correct?
Yes, ma'am. This particular person has not yet been through the tips training. What we do is hire them and get them through the next available class. So new hires have to get through the training right away. This person was in-house training, if you will, the day that this particular violation took place.
But they've gone through the training now?
They have not gone through it yet, but that's in the plan.
It takes a while to schedule that.
They're monthly classes, and, when we have kids in school, et cetera, it can be difficult to schedule. But this person will go through formal tips training as soon as possible.
One thing I don't understand, Counselor, is was this her first night
Yes,
training? Okay.
And it was a
First shift.
Friday night, right?
yes.
so it sounds to me like you're saying that she was put in an unfortunate situation. She's going to go through tips training. That sounds like two separate issues. So is there anything that the establishment has done to make sure that either her or anyone else isn't caught in a place where they're too busy to be able to monitor?
Yes, it's a staffing issue, and we were simply shorthanded that night. And the fact that Mr. Frangis-Kakis is back at the restaurant on a daily basis, I think, is significant. because he can see these things, he can fill in if there's a problem. And we simply didn't have that last level of supervision and it's our failure to have that last level of supervision there that caused this violation. That's why it's my client's responsibility.
I think you touched right on the major issue, if you will. You know, we're sorry for your surgery. I would hate to go through any kind of knee surgery myself. And appreciate your understanding that as owner, you have total responsibility, whether you're present, not present, or whatever. I very much appreciate that. If I maybe use the word often, we often see violations because the establishment is busy, did not have sufficient staffing, or whatever. And it comes back on the owner, as you noted, sir, to anticipate that he needs additional staffing and to have that staffing there. Unfortunately, it led to a violation, and that is what we are discussing today.
Yeah, and, you know, I don't have anything to say that is contrary to that. You know, we got caught in a bad situation. We got caught with a very difficult customer, and we just simply didn't have the staff there to deal with it correctly.
Does the city prosecutor have any sort of recommendation?
Yes, I have recommendations, and I also have aggravating factors I'd like to argue. As I indicated before, this is the second offense that the authority is looking at tonight. The first offense within the last 5 years occurred in December 2009. I want to talk about that one just briefly. It was a long time ago, and some of the authority members have changed. That particular case, when I reviewed it, and I actually handled that one, it was a conduct in an establishment situation. It was a fight that occurred between two gentlemen. Those two gentlemen, at that particular night when they were contacted, one blew a .148, the other one blew a .245. Of note in that, and it was factors that I had considered, the bartender, or the server, excuse me, that was serving the one gentleman that blew the .245, the higher of the two, he never noticed. He told the officers, I never noticed that this gentleman was intoxicated. This gentleman had come into the bar. The gentleman had told officers that he had been drinking at another location, would not clarify as to where. And so there was an argument at that point that he probably did come into the bar intoxicated, or at least came in, I mean, he was .245 when the officers contacted him. And that bartender or the server at that point did not notice that he was intoxicated. They were served 2 pitchers of beer. The second pitcher of beer, I do not believe, was entirely consumed, because that's about when the fight broke out. The other thing I would want to point out is that the gentleman with the higher BAC did, in fact, go to the hospital, and at some point, and the record is not clear as to how much time elapsed, but at the hospital, he had a BAC of .418. So this gentleman, the city would argue, was clearly intoxicated when he was in the bar, and there could have been potentially a service issue as to whether he should have been served to begin with.
Sorry, can I interrupt real quick? Can I clarify? So you're saying at one point, so there was
There's
two
gentlemen.
people. Okay. And at one point, a BAC was .2, and later it rose to .4?
Yes, when officers arrived on scene, Timothy is his name, he blew a .245, and that was at about 12:11. The other gentleman blew a .148. As I indicated before, the report is silent as to how much time it elapsed. He went right to the hospital from the bar, but I'm not sure how much time it elapsed when he was in the hospital before that .418 BAC was taken.
It's my understanding it's normal for it to increase over a period of time.
Absolutely. But 245 is really high, and .418 is
Dead.
Yeah. Then in getting with this situation is very concerning to the city. And while there may be some staffing issues, while there may have been some training issues, there's a couple things that the city would want to point out. The bartender, Miss Parker, who was the bartender that was the one doing the training, she was the one that was in charge. She served the first drink that night, and that's indicative of the police reports that you are all familiar with. Jackie Connor was the person in training proceeded to serve the next 4 drinks. One thing that the city would like to point out in exhibits G, the witness statements, and this is the statement of Jessica Parker. About halfway down the first page, she indicates, after 20 minutes, I noticed she was still, and I can't read this next
Presenting
word.
intoxicated?
Pardon?
Does it say presenting intoxicated?
I'm not sure. But what's important is the next part. I told her to watch the woman. So here we have the person, the bartender, who's in charge of the bar, who's doing the training of the younger bartender. And after about 20 minutes of this woman being in the bar, she tells the person in training that you need to watch this woman. I think at that point there was a knowledge element that was going on. They knew at that point, and I believe 2 drinks had been served at approximately 20 minutes in, that this was someone that they needed to watch. The drinks, Sergeant Iman was the main officer. The drinks were 5 double-shot Jack Daniels. I do have an exhibit F, the bar tabs that were taken that night that Sergeant Iman did take and put into evidence. And you can see from those bar tabs the times and the types of drinks, all of which is in the police report. So shots or drinks were served to her at 5:36, 5:47, 6:04, 6:18, and 6:35. So within 59 minutes, there were 10 shots of alcohol served, essentially. Sergeant Iman was the first on scene. Sergeant Iman indicated that when he spoke with the bouncers, and this is not in the police report, that the bouncers started to escort her out after that 5th drink was taken away from her. This is after Ms. Parker indicated that, and she says it in her statement and in the police report, that she noticed that she was intoxicated and did take the drink away. This is after Ms. Parker told Sergeant Iman that the bar was very busy and it was difficult to watch the lady that she told the younger bartender to watch out for 40 minutes earlier. Sergeant Iman relays that the bouncers indicated to him as they escorted her out of the bar, she in fact face planted onto the concrete outside the bar, went down face first, landing on her stomach due to presumably her intoxication level. They were able to get her to roll on her side, and that's how he found her when he arrived on scene. He arrived on scene at 7 p.m., so it was approximately 25 minutes after that last drink was served, maybe 20 minutes or so after she was taken out of the bar. When he arrived, she's conscious, but she's not responsive. She's not answering any questions that they were asking her. He does at one point, and this is prior to Corporal Dimitrick, who arrived on scene at 7:14. So between 7 and 7:14, he's able to get her to take a PBT. He indicated that she blew into the PBT, but he described it as a very weak blow. And when I talked to him prior to the hearing today, he indicated it was kind of like so not a full deep breath, which is required. And that PBT result was 0.198, which is very high. It's very high for a weak blow. And it's very high for someone who had just consumed alcohol. Arguably, this woman was also on her way up and probably going to the 0.3, 0.4 land due to the amount of alcohol that she consumed. The city is very concerned about this. This is a tremendous amount of alcohol, and it's the city's contention that even if you are a new bartender, 5 double-shot Jack Daniels in less than an hour is a lot. It's a lot for most people that are sitting in this room, and it certainly was way too much for that particular individual. As far as a recommendation, due to the fact that this is a second offense in the last 3 years, and due to the fact that this particular case is very aggravated, very, very aggravated. This woman was beyond what would be considered appropriate in any circumstance. We are recommending 14 days of suspension. We're asking that 7 be held in abeyance, so there would be an actual 7 days served as a suspension. And we're asking that no fine be given in lieu of the suspension.
I'm sorry, you're asking no fine be given in lieu of suspension?
That's correct, that it would be an actual 7-day suspension, and that no fines in lieu of a suspension be
7 days served.
7 days served and 7 held in abeyance.
Can I clarify, the statements from the 2009 incident, were you reading from the stipulation?
I was actually, are you talking about the facts?
Yeah.
I was actually reading from the police report.
Okay.
Portions of the police report.
In 2009.
The 2009 police report.
I remember that hearing.
You have a good memory.
Mr. Stonebreaker,
Very briefly, Your Honor, if I may. It's unusual for the factual basis of a prior violation, which is 3 years ago, to be used as aggravation on a second violation. Usually what occurs is the fact that the first violation was dealt with, the fact that the first violation was heard by the board, and the fact that a penalty commensurate with the first violation was levied by the board 3 years ago means the first violation is over. The fact of its occurrence is a fact of record, but to go back into the underlying facts and who did what and when is very unusual. I will state for the board, I have never seen that take place before. It's a fairly edgy practice, in my opinion. Relative to this violation that the board is dealing with here today, the fact of the matter is the woman in question consumed 4 drinks. We've accepted responsibility for that violation. The 5th drink was simply taken away from the person by the bartender in question. She said that person has had enough, took that 5th drink away. So there was intervention at some point. It wasn't a matter of benign neglect. It was just as soon as the bartender saw there was a problem, she dealt with it immediately. What I want to say is the police report also indicates that there was a strong assumption by the officer investigating that the lady had a medical condition. The police report talks about a medical band, which he thought was a diabetes band, being in place relative to this particular lady. Again, we are not discounting the fact of the violation, but there is mitigation there. This person was extremely overweight, someone that you would associate with diabetes. We agree that it was the fact that she fell. We were the ones who called for medical attention the minute she fell. And that was how this whole incident got started. But my client was the one, or the bartender in question, was the one that called the ambulance right away the minute she fell. So it's not this benign neglect or failure to observe. It's dealing with the case as rapidly as possible given the facts that were presented. The last thing I want to object to is the characterization of these blood alcohol tests that were taken after the fact. The issue here is, was the person visibly intoxicated when served, not what their blood alcohol was later. Some people have very low blood alcohols and act intoxicated. Some people can have extremely high blood alcohols and not appear to be visibly intoxicated. I think it's easy to look at the number because the number is easy to see and it's easy to quantify, but placing the blood alcohol as an aggravating factor in this particular case, I think, is simply wrong, because the violation that my client is accepting responsibility for is service to a visibly intoxicated person. The blood alcohol is taken after the fact, and there's no correlation in time.
May I ask real quick, how would you say there's no correlation in time? I mean, there's no evidence that alcohol was consumed from the time she was served to the test. I don't see how there isn't a correlation.
Mr. Cole, you just don't know what a person looks like when they've been served X number of drinks.
But we've already reached the stipulation that she was overserved. The question is, whether or not that should be taken into account as an aggravating factor. And my question is, how could it not? I mean, whether or not, say, she was to consume alcohol before she came in, from the time she consumed alcohol until she took the blood test, I mean, I don't understand how there's not a correlation, is my question. Because the blood alcohol is taken at a time subsequent to when she was served. And different metabolisms deal with alcohol differently. If there was a way to take the blood alcohol that was legal at exactly the point she was served, then there's a correlation between the visible intoxication and the blood alcohol content. But the visible intoxication occurs at a different point in time than the blood alcohol is taken. And I just think that the discrepancy in time, what we're asking is, was it reasonable for the bartender to serve? We agree that it was not, but I don't think that has anything to do with blood alcohol. The bartender doesn't have access to blood alcohol tests. I guess I challenge the idea that it doesn't have anything to do with. I can understand a statement that blood alcohol later isn't the blood alcohol at the time she was served, but the idea that it doesn't have anything to do with the situation we're looking at seems, I guess I would just challenge that.
Fair enough. I just don't think it's probative of anything. It's just a number on a scale. We don't know how it relates to the person.
I'm looking at this police report. I don't see any mention of a medical alert bracelet or necklace or anything like that. Can you show me on this where it says that?
I read that someplace. If you want to give me a minute, I don't know that it's that important, but in preparing for the hearing,
it's been presented as a mitigating factor, and then I think that if it's not valid, then it's not a mitigating factor.
Okay, let me take a quick look. The last thing I want to say is this. I appreciate that the city takes this seriously. So does my client. It's clear to me that my client has gotten the message. I don't think the 14 days of suspension with 7 days served, it strikes me as extremely harsh in these particular circumstances. It has been 3 complete years since my client had any kind of a problem relative to the liquor code. I agree that it's a second violation, but I also want the board to consider that it's been 3 complete years since the first violation. There's nothing magic about the 5 years that's being indicated by the city. There's no statutory authority for anything relating to 5 years. What I'd like to suggest is if the board is going to assess 7 days served, that perhaps a closure of 1 or 2 days would be appropriate, and that my client be granted the ability to pay a fine in lieu of, for instance, the remaining 5 days. And I think the punitive effect of a 2-day closure is the same as the other. The other point is this. My client intends to stay open for food service during the days of suspension because we have a regular food clientele that we need to service. The days of suspension impact very harshly on the hired help. They rely on tips that are generated from alcohol for their living. And if we shift the economic impact to a fine that's paid by the establishment, we shift the economic impact away from the employees of the establishment. So that's why I'm suggesting that if the board finds that the 7 days served is the appropriate number, my suggestion would be maybe 5 of those could be done via a fine in lieu as opposed to actually serving the days.
May I ask you, I want to challenge again that you said very harsh and punitive used as words to describe. Our guidelines approved by City Council, list of offenses with recommended guidelines for sanctions under the liquor code. Under sale or service to visibly intoxicated persons, second offense, 14 days suspension with 7 days held in abeyance for 1 year, no fine in lieu of suspension. So I guess my question is, based on a published guideline that we're looking at from City Council, I again challenge the idea that it's harsh or punitive, and I would ask, I mean, have you seen this, and how do you react to what I'm looking at as a guideline that we use?
I haven't seen the specific guideline, and it strikes me that when we're talking about a second violation, we're talking about the same offense.
Just a moment for clarification. I don't think it's a guideline from the City Council. I think it's a guideline from the City Attorney's Office. Is that correct or no?
No, the licensing authority guidelines were adopted by council.
They were adopted by council? Okay.
A question I also have is I know at some point we were going to enact fines. I was not aware that that had been established yet.
Yes, it has.
It
has?
is. They're part of the same guidelines.
Guidelines, okay.
What has been established?
Fines.
The possibility of fines and lieu of suspension.
Fines in lieu.
That's true.
So again, I mean, I think you may have gotten cut off. And when you say the same offense under both conduct of premise and sale of service to an invisibly intoxicated person, the guidelines state for the second offense, 14 days with suspension, 7 days held in abeyance, no fine in lieu of suspension. So I don't know that there's a problem between the two because, again, the guidelines would state that. So I guess my challenge is what is it that should change the guidelines here that we're looking at?
Because my client's establishment is not a problem establishment. He has run an exemplary establishment for 3 years. We agree that an incident took place. It took quite literally the perfect storm to produce this violation. And there's nothing that indicates that it's an ongoing chronic type problem that needs to be met with a high degree of discipline. I appreciate the city has the guidelines. I think the reason the licensing authority is here is to make the determination on a case-by-case basis. And I apologize for my extreme language earlier. It's a bad...
Well, no, but again, when you say a high degree, I mean, this is the basis. And the guidelines state, mitigating or, or aggravating circumstances may go either way. My point is, what I'm reading, this is the middle. And so it doesn't seem to me like it's harsh or harsh maybe if we went twice, if the city had asked for 2 times over the guidelines. So I guess that's where I'm struggling to understand how it's being interpreted as somehow above and beyond.
Well,
If I may.
because I'm looking at it from the licensee's perspective, that may be the answer, but I think that's the decision for the board to make. But I think there's a lot of room for leniency in this case.
Can the city attorney tell me the last time that this authority imposed 14 days for a second offense?
That's the point I was going to make. Mr. Stonebreaker's been before us before. I recognize you, and this is the standard, but it is more than we've done in the past, I think.
Yeah, I think
those of us that
you're
have been
into
on the
discussion
authority
now
for a
instead of
long time, we have the discretion to do whatever penalty we feel is right. We can follow these guidelines, or we cannot follow these guidelines.
We can be less severe or more severe.
Yeah,
Yeah,
in defense of Mr. Stonebreaker's point, compared to other penalties we've given out, these are severe penalties.
You're into discussions now instead of into public testimony, sir.
Okay.
But
Why don't I sit
but
down
would
and
point out the
allow
fact-
that discussion
I would
to
come back,
proceed?
excuse me, sir. I would come back to the fact that you were concerned about bringing in prior violations in that. And in fact, city municipal code, section 3214, brings in, number one, we looked at the seriousness of the violation. And I think it can be considered a very serious violation. Number two, we look at corrective action. And that's still my major concern about corrective actions. It's been some, but not much.
Well,
Number three, wait a minute. Number three is prior violations. So we do look at prior violations. It's the third most important thing we look at. And I'm still concerned about corrective actions that's been taken, which is the second most important thing we're supposed to look at.
Well, in my estimation, they have taken some corrective action, being that they have this bartender scheduled for tips training, and all their servers and bartenders have tips training. I know for a fact that it takes a while to schedule that, sometimes 6, 8 months to get into one of those classes, and maybe she shouldn't serve alcohol until she has a class. I don't know, but also you have to look at, in mitigating factors, that what's the likelihood of recurrence? what are the circumstances? This is a one-time thing. This isn't an establishment that's here for a renewal hearing on an annual basis. We don't have a lot of police reports, unless I'm mistaken. Is that a fair assessment? Okay. I don't think they did it on purpose. There's no willfulness of violation. Hardship on the licensee, I don't know. It might be a hardship on the employees. It would be more of a hardship on the licensee if we were to give him a fine. He's had the license for how long? 5 years? We had one incident where they had 1 day and it was held in abeyance. Is that true?
What's your question?
1 day suspension and held in abeyance?
That is correct.
I didn't want my reading of the guidelines to I just wanted to make the point that these are the guidelines, and I agree that in the past the authority has not imposed those kind of penalties on a second offense, but these guidelines were adopted since then. So I did just want to make clear to the authority that that's what we're operating under, and if we do find reason to find a penalty less than that, then so be it. But I wanted to make clear that those are the guidelines. So I think if we decide to find something less, we ought to have reasons to do so.
That's fair.
And just to let the authority know, I was involved.
That's a fair comment.
I was involved in a little bit of the development. These guidelines weren't just pulled out of a hat. Kirsten Crawford did look at other jurisdictions, what they do. Most notably, Aurora was one that we did focus upon because they have a very active liquor authority. So there was a lot of research and thought and work done behind these guidelines. So it wasn't just something that we kind of pulled out of the thin air before we presented to both you and City Council.
I'd like to go back to a comment made by Gallagher, Tony, if I may. I'm still concerned about corrective action. We had basically 2 servers here. One has been totally trained, and one's in training. And both of them appears to have gone or not going above and beyond. Okay, and the fact that you say that, okay, we're not going to, this one that hasn't been trained, yeah, we're going to train it with tips, but it might be 8 months. I'm still concerned about what corrective action is being taken today to prevent a reoccurrence.
Well, I do think that they did make the point that there is now an additional staff member being the owner who's so I would note that is also most certainly something that's some action that's been taken, and I would understand that.
Who's not the bartender?
The senior bartender.
Is she a server?
Yes, that was something I was thinking. Your attorney said that as soon as the bartender knew there was a problem, she took care of the situation. But according to what the city attorney says, she told the new bartender, watch her. And I think she should have stepped in and taken over that situation herself.
So there have been corrective actions taken. Maybe not enough to placate you, Earl, but there have been some.
I appreciate that there is some corrective action taken.
Well, I'd like to put a little weight on the fact that now Mr. Frangeskakis is present in the establishment at all times, whereas he wasn't then. So you've improved the supervision, overall
1,000%.
supervision.
Supervision is approved 1,000% by my presence. I don't allow that. My record speaks for itself for the 30 years that I've been, the numerous liquor licenses that I have possessed. I have never, ever been in trouble.
If I may, I would make a motion, sir.
Of course.
Based on foregoing evidence and testimony, I move the authority find that the Old Mill Brewery did violate Littleton City Code Section 3-2-10F. And based on said finding, I move that the Littleton license for the Old Mill Brewery be suspended for 10 days with 7 days held in abeyance for 1 year. And that notice of such suspension be posted in and outside of the licensed premises in accordance with the Liquor Code Regulation 47-600F. And that suspension be served on or beginning Does it have a recommended date?
I believe that usually is a question for the licensee of when they would request that be
10
served.
days total, 7 held in abeyance.
10 days, 7 in abeyance. Okay, so 3 days.
Do you have a recommendation on the date, sir?
Yes, sir. We're going to suggest being closed January 1, January 2, January 3. However, I would like to ask the board for the ability to pay a fine in lieu of actually serving the 3 days.
I understand that, sir. I'm dealing with the date right now.
I understand.
Does the city have a comment related to the date?
We're not clear that we have time to post the property in that amount of time. Hold on, we're looking.
I would
I
ask
would
the
serve
city what,
beginning on 7 January 2013, and that there be no fine authorized in lien of suspension.
I'll second for the purpose of discussion.
Could I just clarify that the violations that we stipulated to were not only 3.2.10F, but also the Colorado Revised Statute Section 1247-9011A?
Right. So I'll second for the purpose of the discussion.
Okay, but I will agree with the city in adding that violation.
Okay. What day of the week is the 7th?
That's
Monday.
A Monday. So Monday the 7th,
Monday,
Tuesday the 8th,
And Wednesday.
Wednesday the 9th.
Is that acceptable, Mr. Stoneberger?
We don't have any objection to those particular days. The issue for me is the ability to pay a fine.
The issue of the fine, as I understand it, is that you have to produce your average receipts for a day's business or something like that.
Precisely. I would suggest that we would take basically the last 60 days or the last 2 calendar months, alcoholic beverage sales, find a daily average, document that to the city, and then the fine is 20% of the daily average for the 3 days that are under consideration. So we would get to a 60-day daily average alcoholic beverage sales, and then the fine is 20% of that amount worked through the 3 days.
There has been a motion, there has been a second to the motion. I believe the discussion now is strictly among the board.
So
I think you're right.
So I think my thoughts, I don't know that since the motion itself has already gone below the guidelines, I don't know that I don't find further mitigation that would allow them to pay a fine instead of the closure.
You're suggesting that they'd be allowed to pay a fine?
No, I'm saying I don't find further mitigation that would justify that. And so if we were to suspend the license for those 3 days, notice would be posted. If we were to allow them to pay a fine instead, would notice be posted? Because to me, part of making sure that something doesn't happen again is
Fine, there was no notice,
right. And to me,
because there was no suspension.
part of making sure that something doesn't happen again is, you know,
The public notice.
right, the public notice that, so I think that I would support the motion as is.
I would support this motion, and one of the thoughts that I have is, long as I've served on the authority and the time I've observed the authority before I was a member, is that the rest of the community that is in business and is serving alcohol takes notice of what we do. And the fact that this is perhaps below what the guideline that the council set forth is, it's still considerably higher than what we've done in the past. This might be a good point to get the community's attention and have them know that this is something that we were going to be dealing in a more strenuous manner from now on.
In making the motion, you know, I considered all the circumstances, obviously, and I also considered the fact in holding 7 days in advance, that's a hammer over the head for the next year, and that's where I come back to corrective actions and making sure it doesn't happen again, because if there is anything within the next year, he's got whatever that is, plus that 7 days hanging over his head.
I'll be in the minority and be inclined to go along with a fine in lieu of the days served, just because this is, once again, a higher total penalty than we're accustomed to handing out. And I think that the message is there. And I would not have a problem with a fine in lieu of the 3 days.
I suggest we vote on the motion.
As soon as we finish our discussions, anyone else have?
I think I support the suspension. I'm going to go with that one. And I have to take into consideration that it is a second offense. You know, I can't discount that. And it is a very high level of alcohol that was served. I might go with the 10 days with, you know, no, I'm good with it. I'm good with yours.
I think it's time to poll the authority.
Authority Member Bradish?
No.
Authority Member Gunya?
Yes.
Authority Member Cole?
Yes.
Authority Member Odell?
Yes.
Authority Member Mather?
Yes.
Motion is carried.
We wish you good luck, and we hope never to see you here again.
Mr. Chairman, members of the board, we appreciate your time and attention this evening and your fair consideration of our request. Thank you.
Thank you.
You're welcome.
Thank you. No?
There are no other indicated agenda items other than item 18, which asks for reports from staff, authority members, and chairman. Do we have any of those? Then, having no further business before the authority, I declare this meeting adjourned.
He'll probably want his menus back.